Hi everyone, good evening. I hope you're ready for another study session with me. I'm going to be your virtual companion in studying the general provisions of obligations under Article 1156 to Article 1162. So let's get down to business. So we have here an obligation. So in this video, guys, we will be defining what is an obligation, what are its essential requisites, what are the different forms of obligations, different kinds according to subject matter, and the sources of obligations. Now, for the definition of the obligation is being defined under Article 1156, which states that an obligation is a juridical necessity. Okay, an obligation is a juridical necessity to give, to do, or not to do. So here, this stresses the duty under the law of the debtor or obligor, or he who has the duty of giving, doing or not doing. When it speaks, the obligation is a juridical necessity. When we say juridical necessity, we mean that in case of non-compliance, the court of justice may be called upon by the aggrieved party, so yung nadihado, to enforce the fulfillment or in default thereof, the economic value that it represents. So, in a proper case, the debtor or obligor may also be made liable for damages, which represents the sum of money given as a compensation for the injury or harm suffered by the creditor. So, suffered by the one who has the right to the performance of the obligation for the violation of his right. So, we have here to do or not to do, positive personal obligation and a negative personal obligation. To give, kama pala to, diba? To give, kama, diba? So, let's stress that. Let's change muna that one. To give, kama, to do or not to do. Okay, so, let's check. To do or not to do. So, we have the real obligation, yan na. Okay, so we will discuss it naman din dito sa kinds of obligations according to subject matter. But to give, that's the real obligation. To do, a personal obligation, positive personal obligation, or not to do, which refers to the negative personal obligation. So that's Article 1156. Now, what are the different or what are the essential requisites in a obligation? So every obligation, guys, has 4 essential requisites. Namely, we have passive subject, so active subject, the other one we have object or prestation, and the juridical or legal tie. So i-correct na lang din natin siya habang maaga pa. So that is juridical tie. Okay, so you have juridical. Okay, yan. So you have the essential requisites. Please take note, the passive subject, active subject, so these are the parties, object or prestation, juridical or legal tie. So, sino ba si passive subject? So, siya si debtor or obligor. Passive subject also known as debtor or obligor. So, he is the person bound to the fulfillment of the obligation. So, he who has a duty. So, siya yung kailangan na may gawin. Okay? Bound siya, may obligation siya to do it. Next is the active subject, also known as the creditor or obligee. This refers to the person who is entitled to demand the fulfillment of the obligation, or as in simpler terms, he who has a right. So, for these are the parties, passive subject, active subject. Minsan tinatawag din si passive na debtor or obligor, or si active subject tinatawag din naman natin si creditor or obligee. Sometimes I get confused on sino si obligor, sino si obligee, di ba? Saan ba gagamitin si passive tsaka si active? So, yung ginawa ko, kinuha ko na lang yung P, D, PDR. So, pag sabihin PDR, passive debtor obligor, isang tao yon. So, ACE, so parang mnemonics ko, you have active subject A, active, creditor, obligee. So, ACE. So, para mas madali, pag sabihin obligee, so okay, alam ko na si active subject yung ibig sabihin to. Okay, si creditor pala yung ibig sabihin to. Okay, next is the object or the prestation. So, what is the object or prestation? You have the subject matter of the obligation. And take note, in order to be valid, the object or prestation must be, so here are the requisites. So, kasi nga, this is law, so we need to be lawful, diba? Dapat, in order to be valid, meron siyang nilalagay na requisites. Okay, the subject matter, which is a corresponding, okay. So here, in order to be valid, the object or prestation must be first, licit or lawful, okay, within the bounds of law, possible physically and judicially. Mahirap naman din, di ba, ang obligation. May tinatawag din tayong impossible obligation. Oo nga, kinakailangan niyang gawin, pero it's impossible to do it. So, kinakailangan, if you have an object or prestation, it must be possible. It must be possible. Next, in order to be valid, it must be determinate or determinable, and the pecuniary value or possible equivalent in money. Take note that the absence of any of the first three, okay, iba pala to, so makes the object void. Okay, absence of any of the first three, okay, makes the object void. So, for example, magnanakaw, object ng agreement or like that, di ba? You are obliged to deliver shabu, di ba? It's unlawful. So, that obligation is void. Oo nga naman. Bakit man naman? Gusto mo siyang makulong? Hindi naman, no? So, ayaw mo naman din may ganun na mga usapan. Next, essential requisites of obligation is the juridical or the legal tie. It is also called efficient cost. So, pag sabihin juridical tie or legal tie, efficient cost, same lang yon. This is that which binds or connects the parties to the obligation. So, take note of these essential requisites. So, dapat na yan, okay? So, yung juridical tie, legal tie, efficient cost, sinatawag din vinculum juris, yan. Siya yung, so, it could be established by law, bilateral acts, or unilateral acts. Okay? So, just remember those terminologies. Okay? Next is the form of obligations. So, what are the different forms of obligation? Actually, general rule is that the law does not require any form in obligations arising from contracts further validity or binding force, which is expressly provided under Article 1356. However, we have exception to the rule. These two, yung dalawa, yung when the form is essential to the validity of the contract as required by law, that's Article 1346, and another exception to the rule is when the contract is unenforceable unless it is in certain forms, such as those under the Statute of Frauds as formulated in Article 1403 of the new Civil Code. I think I've already discussed an enforceable contract in one of the videos I've posted. Parang may nag-request, so inuna ko siya. So, ayun. I've discussed in one video yung unenforceable. And hopefully, I could also have videos on what are the different kinds of obligation pag, maraming time. Diba? Bigyan natin yan ng time, guys. So, next, obligations from other sources under Article 1157 do not have any form at all. So, yon yung different form of obligation. Just remember, general rule, wala. Pero, there are certain circumstances or instances na merong kinakailangan i-follow to be valid and binding to both parties. Now, what are the different kinds of obligations according to the subject matter? So, yun na nga. yung real obligation tsaka yung personal obligation. Pag sabihing real obligation, that's obligation to give. Pag sabihing personal obligation, it could refer to a positive personal obligation, which is an obligation to do. Okay, positive to do, kinakailangan mong gawin, or a negative personal obligation, or an obligation not to do so. You just remind yourself to the definition as provided in Article 1156. An obligation is a juridical necessity to give, okay, to do or not to do. So that's Article 1156. Now let's move to Article 1157, which provides the different sources of obligations. Ayan. Diba guys? Ang ganda-ganda ng law. Kasi logical law nga. Illogical yung pagkakasunod-sunod niya. You have Article 1156, the definition of obligation. Article 1157 provides, enumerates the different sources of obligations. And then the next succeeding articles, such as Article 1158, refers to obligations arising from law. Article 1159, which refers to obligations arising from contracts. Article 1160, which discusses obligations arising from quasi-contracts. Article 1161, which provides for obligations arising from crimes or omissions punished by law, and Article 1162, which provides for obligations arising from quasi-delicts or torts. O, diba? Ang ganda-ganda. So, let's start with law. Obligations arising from law. Ano sabi ng Article 1158? Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. So, ito yon. Hindi pwede na presumed. Bakit? Because it is considered as a burden upon the obligor. So, what are the characteristics of a legal obligation? First, it does not need the consent of the obligor. Second, it must be expressly set forth in the law creating it and not merely presumed, kasi nga burdensome yung obligations arising from law. So, it must be expressly set forth because these are exception and not the rule. And to be demandable, they must be clearly set forth. Okay? Oo nga naman. So, kinakailangan yun. Ilagay talaga yun. So, in order that the law may be a source of obligation, it should be the creator of the obligation itself. So, that is under Article 1158. So, how do we determine whether an obligation arises from law or from other sources? So, paano natin malalaman kung does it arise from law or yung contract ba, quasi-contract ba, crimes or omissions ba, quasi-delicts? So, ito daw, if arises from law, if it establishes an obligation. Okay? However, it arises from the act itself if the law merely recognizes the existence of an obligation generated by an act. So, pag it arises from law, when it establishes an obligation. So, what could be an example of of that? So, we have the obligation of the spouses to support each other. So, that is expressly stated in our law, family code. May ganon. So, next, yung obligations arising from contracts. Okay. Ito, maikli lang yung Article 1159. It provides that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. So, take note, in Article 1380, diba, merong separate na, the law on contracts, kaya nga ito tinatawag na the law on obligations and contracts, yung sa business law 1. So, aside from obligations, we are going to discuss contracts. And contracts, under Article 1318, yung it must contain all the essential requisites of a contract. So, what are the essential requisites of a contract as provided in Article 1318? So, ito yung reference na provision. So, according to Article 1318, there is no contract unless the following requisites concur. First, you have the consent of the contracting parties. Second, the object certain, which is the subject matter of the contract. And finally, we have the cause of the obligation, which is established. So, these are the elements essential elements of a contract. So take note, aside from those being mentioned, it must not be contrary to law, morals, good customs, public order, and public policies provided in Article 1306. So, okay. So dalawa na. So, we have law, contracts as sources of obligation. Now, let's move to quasi-contracts as provided under Article 11, 60. Okay. Article 11, 6. So, quasi-contracts are juridical relation arising from lawful, voluntary, and unilateral acts based on the principle that no one shall be unjustly enriched or benefited at the expense of another under Article 2142. An example of a quasi-contract is meron tayong tinatawag na solusio indebiti at meron din tayong tinatawag na negotiarum gestio. So, para masundan nyo guys, meron naman tayo dyan sa Article 1160. Ay, oo nga pala. With respect sa contract, meron tayong tinatawag na compliance in good faith. Okay? So, in contractual obligation, there must be compliance in good faith, which means compliance or performance in accordance with the stipulation or terms of the contract or agreement. Sincerity and honesty must be observed to prevent one party from taking unfair advantage over the other. Ano pa yung sabi niya under sa obligations arising from contracts? Non-compliance by a party with his legitimate obligations after receiving the benefits of a contract would constitute unjust enrichment on his part. So, yun nga. Punta na tayo sa different kinds of quasi-contracts. So, ano ba yung characteristic ng quasi-contract? Take note of these words: lawful, voluntary, and unilateral act. Isa is the principal kind of quasi-contract is negotiarum gestio, which refers to a voluntary management of the property or affairs of another without the knowledge or consent of the latter. So, let's say for example, yung kapitbahay mo wala dyan, hindi naman din binilin, di ba? Hindi naman din sinabi sa iyo na, ay, pakibantayan yung bahay ko, ganun-ganon. Pero, ikaw naman, di ba, because you're a good neighbor, binantayan mo din naman, di ba? What if merong magnanakaw or merong sunog, nagkaroon ng sunog, tapos you help put off the fire or tinulungan mo siya even if nobody told you to do it, di ba? Parang ganun. So, in that case, the owner of the house is under the obligation to reimburse you, okay, for any expenses. Although you did not actually give your consent to the act in saving the property, no, on the principle of quasi-contract. Another one is the solusio indebiti, which is your juridical relation created when something is received and there is no right to demand it and it was unduly delivered through mistake. So what are these other requisites you have here? Wala kang karapatan to receive it, and the other one, it was delivered to you through mistake. So, let's say for example, I owe A, say, nangutang ako kay A ng pera amounting to 1,000. Now, I thought that inauthorized ni A si B. Okay? Inauthorized ni A si B para kunin yung payment. However, hindi naman pala niya inauthorize. So, ano ba? Libre na yun? Kay B na talaga yun yung pera? No, actually, sabi ng law, no, the obligation to return on the part of B arises. So, if it was paid by mistake, yun naman yung requisite, you have no right to receive the thing, and that the thing was delivered through mistake. So, that is a quasi-contract. So, remember, negotiarum gestio or solusio indebiti. Next, source of obligation. One of the sources of obligation are crimes or omissions punished by law, which is provided under Article 1161 of the New Civil Code. The general rule is that As provided in Article 100 of the Revised Penal Code, every person criminally liable for a felony is also civilly liable. So what are the exceptions to this rule? We have crimes of treason, rebellion, espionage, contempt, and others wherein no civil liability arises on the part of the offender, either because there are no damages to be compensated or there is no private person injured by the crimes provided in the Book of Reyes. So, meron daw kaakibat na civil liability for every a person criminally liable. So, what is the scope of civil liability? You have here restitution, reparation for the damage caused, and indemnification for consequential damages. And finally, last but definitely not the least of the sources, you have quasi-delicts or torts provided in Article 1162, which is being defined as an act or omission arising from fault or negligence which causes damage to another, there being no pre-existing contractual relations between the parties. What are the requisites of quasi-delict? So, take note, there must be an act or omission. Okay? Next, second requisite is that there must be a fault or negligence. Next, dahil sa negligence na yun, it causes damage to another. And that there must be a direct relation or connection of cause and effect between the act or omission. So, dapat merong ito, act or omission. So, ano yun? The act or omission daw, kinakailangan may direct relation or connection between this one, and the cause and effect, of course, of the damage. So, yung act or omission, yun ba talaga yung dahilan kung ba't nagkaroon ng damage? It arises from fault or negligence. And, of course, there is no pre-existing contractual relations between the parties. Okay, I think that would be all for this video. So hopefully you will be familiar with the terminologies used because this is the introduction ng general provisions of obligation. And next video, hopefully I could give you the effects and nature and effect of obligations. So just remember, guys, yung in the understanding of the obligation and contract, you just need to know the basic concept. Okay, this is Business Law 1 for business administration students, accountancy, and of course students or lovers of law would want to learn obligations. So we have here definition, ulitin ko lang the outline of this video. We have definition, essential requisites, form of obligation, kinds of obligation according to subject matter, and the sources of obligation. If you want a copy of this one, kindly send you can may PM ba dito sa YouTube or just comment below kung gusto niyo yung document nito, okay, to grab a copy. So, of course, that would be all. But before that, I just wanted to please share and subscribe to my channel for more study session, okay? And of course, remember in yung motto, do not just wait to be an inspiration, be the inspiration. Keep safe, everyone, and please don't forget to pray naman, okay, for safety of everybody and yung, of course, of our frontliners and those who are researching for the cure of this pandemic. So, hoping for the best, guys. Good night. Bye.